Hello everyone, welcome to my channel GSP Studies. Get ready for the dictation. 5 seconds. Start. This application is at the instance of the plaintiff and is directed against the order number 85 dated August 22, 2013 passed by the learned civil judge (senior division) First Court, Alipur in title shoot number 38 of 2007, thereby disposing of two applications, one filed by the plaintiff and another by the defendant, wherein the plaintiff has been directed to deposit the assessed stamp duty of rupees 78,75,063 as per assessment of the stamp duty and penalty by the collector. Para. In a suit on the basis of a development agreement relating to an immovable property, the question of valuation of the suit property and the payment of stamp duty and the penalty thereon arose. The matter come up before this court and by an order dated September 26, 2011 in CO number 3163 of 2011, this honorable court directed for reassessment of the valuation to be made for the purpose of the stamp duty payable together with penalty for impounding a deed. Thereafter, the learned trial judge referred the matter to the collector for determination of valuation, and he submitted the market value of the property to the tune of rupees 1124,86620. Para. The stamp duty chargeable thereon comes to rupees 78,74,063 and the penalty thereon has been determined at rupees 1,000, and thus the total amount payable for impounding is to the tune of rupees 78,75,063, and this is apparent from annexure P/3 at page number 52. The defendant has filed an application for a direction upon the plaintiff to pay such stamp duty and penalty, and the plaintiff has filed an application for rejection of the report of the collector. On the basis of such assessment, the learned trial judge passed the impugned order directing the plaintiff to deposit the said duty along with the penalty. Both the applications have been disposed of accordingly by the impugned order. Being aggrieved, this application has been filed. Para. Now the question is whether the impugned order should be sustained. Para. Upon hearing the learned advocates of both the sides and on perusal of the materials on record, I find that in order to shortcut the matter to come to a decision over the matter in dispute, it may be recorded there herein that by the order dated September 26, 2011 in CO number 3163 of 2011, one of the learned judges of this honorable court has directed as follows in the matter. Para. In the result, the order impugned stands set aside. The learned judge is once again requested to act in terms of the earlier order dated May 19, 2011. The parties shall be liberty to present documents before the learned judge to enable him arrive at the correct figures. Once the stamp duty payable together with penalty is assessed in accordance with law, the petitioner may proceed to act in terms of the order to be passed by the learned judge, and in such event the instruments in question shall be admitted in evidence, and follow-up action shall be taken by the learned judge in terms of section 38 of the Act. In the event the learned judge is unable to access the amount of stamp duty and the penalty payable by the petitioner, or if the petitioner disputes the assessment, once again the learned judge shall refer the matter to the collector for appropriate decision in accordance with law. Para. Upon receiving such a direction, the learned trial judge himself did not decide anything, but he referred the matter to the collector, who assessed the stamp duty and the penalty payable by the plaintiff public petitioner herein to the tune as indicated above. Para. Thus, I find from the aforesaid facts and circumstances that the first part of the order passed by this honorable court has not been followed by the learned trial judge. The parties were given liberty to present documents before the learned trial judge to enable him to arrive at a correct figure. This has not been followed by the trial judge. When the matter was sent to the collector, he assessed the stamp duty and the penalty to be paid by the petitioner to the tune as recorded above. Stop para. It is pertinent to mention that when the matter was sent to the collector, the petitioner sent a representation to the collector indicating that he might be permitted to present his contention as to the valuation, and that the valuation should be assessed as per amended provisions of the Indian Stamp Act as applicable by the amendment by West Bengal Wide Annexure P/2 at page number 47. But such submission of the petitioner was not attended to by the collector at all. Stop. ভিডিওটি ভালো লেগে